Senator Whitehouse.
Thank you, Chairman. Let me first observe for my colleagues here that sanctuary city is a political term. It's not a technical term, as your own witness has acknowledged. And it's important to get things right. So I want to just describe what's happening in Rhode Island. In Rhode Island, our federal district court has decided that local and state police officers can be held liable if they hold a person under an ICE detainer without a proper warrant, that the warrant requirement actually applies. And particularly when you're dealing with someone's freedom, detention. And that decision is not a fluke. It has been upheld by the United States Court of Appeals for the First Circuit. So in my state, the District of Rhode Island from a federal point of view, and in my circuit, the United States Circuit Court of Appeals for the First Circuit, it is binding law that state and local officials who hold somebody under an ICE detainer where ICE hasn't bothered to get a warrant can be held civilly liable. So we need to face that fact because that's actually binding federal law. The second comment I want to make is about the behavior of ICE agents when they operate in Rhode Island. Those of you on the Judiciary Committee will remember me describing this set of affairs to then Secretary Noem. So masked agents appear in the Rhode Island Superior Court courthouse. They are operating in violation of an agreement that they have with the court not to operate in that courthouse. They are operating with cameras in violation of a courthouse rule that forbids taking photographs. They are pursuing a 30-plus-year-old individual whom they have mixed up with a high school intern who is interning for one of our state court judges. The state court judge is going to take the intern back to high school, so they walk out to the judge's car. If the ICE agents hadn't bothered to figure out who the judges were in the courthouse, when they got to the car, parked in a judges-only spot, they had the information necessary to deduce that this might be a judge. But rather than accept the judge's representations that he was returning an intern to the high school, I'll take out the full F-bomb because they used the actual full word. They told the judge, we're going to smash your effing windows and we're going to drag you out of your effing car if you don't turn over this intern to us. And then they grabbed the intern and they took him into another car for half an hour and figured out that the high school intern was not the 30-plus-year-old person they purported to be looking for. Why would regular law enforcement, why would those sheriffs in the courthouse want to cooperate with an agency whose law enforcement behavior is so wildly irresponsible and unprofessional? It's hard to imagine. And when I asked Secretary Noem about the problem of deconfliction, I think pretty much everybody in law enforcement understands what deconfliction is. Even if the state police aren't cooperating with the Bristol police, when they run in to do a raid in Bristol, they will let the Bristol police know that they're going to do a raid so that when calls come in about cars in the street or people with guns or whatever, the local police department know what's going on. Deconfliction is elementary stuff that is taught to law enforcement. And yet, ICE refuses to deconflict. And the secretary didn't know the difference between deconfliction and cooperation. So clearly there's a massive hole in the way in which DHS thinks about this stuff. And it is in that environment that I think a lot of sensible decisions are being made by local police chiefs about whether they want to cooperate with an organization that behaves in unreasonable and unprofessional ways, that threatens judges with violence, and that refuses to even give them the courtesy of deconflicting when they're operating in their jurisdiction. Thank you, Chairman.